An echo from my side?
No, sir, audio is clear. Studio and quality is good. I can hear you clear. There's no echo.
Now?
Yeah, now there is echo.
Yeah, because from office itself, someone joined from outside, so the audio is.
No, now it's clear, but mere unmute. Maybe if there is another device nearby,
Yes.
then we will have echo, or else it should be good, sir.
An echo from my side?
No, not at the moment, sir.
Okay.
We have few participants coming in. We'll just wait. And with I don't know if it's our colleague or. So we are also live streaming this to YouTube right now. Okay, I'll just hit record so that it's good for shorts. Yeah. Hello all, good morning. Welcome to Eeva Patent Services. And every week on Wednesdays between 11:30 to 12:30, we conduct this live webinar to educate our clientele to share our knowledge in IP or intellectual property rights. Mainly, we specialize in patent law. And we have provide expert advice for almost all the services to various businesses, not only ensuring the protection of the innovative ideas and intellectual property, we also help lots of MSMEs or startups to navigate the complex world of intellectual property rights, IPR. So mainly with patents or safeguarding the future of business with respect to various successes in business. So we've been doing this for over a decade, 13 plus years of committed work under the leadership of Srinivas Madhipati Garu. So it's lots of committed work which we had shown to many of our clients. So right now the numbers are 17,500 plus trademark applications since 2012, 2,500 patent applications, and more than 6,000 patent searches conducted. And there are 25,000 patent illustration jobs worked on. And we've helped over 10,000 plus individuals or inventors or startups or MSMEs throughout India, not only the Telugu states. And also, we're helping IPFCs, EDCs, or top institutions, enabling them to identify and file their IPs. So again, today's session with trademark objections, probably one of my own experience also might fall under descriptive mark or similar mark. So under our IP attorney, Srinivas Garu, he is a registered Indian patent agent with 17 years of IPR domain expertise. With a mechatronics engineering background and a law degree. He's also an author, startup consultant, and a mentor. So with the Eeva's path, we would love to share our expertise and leadership with the startup community and with all the participants who are joining in. So most of us could be the Eeva staff here, but we would love to connect with all of you through our socials, through our social media handles again. And if you're watching the replay or live, probably through any of the short, feel free to get in touch with us at contact@eeva.com. So over to you, Srinivas Garu, with the showcase hearings of the trademark applications. Thank you, sir.
Thank you, Raj. Good morning and very warm welcome to today's webinar titled Trademark Tug of War. So this has been coined by Raj himself. I gave the title as Trademark Showcase Hearings and Avoiding Pitfalls, but he rightly coined it as Trademark Tug of War. Thanks for that. This session is crafted to provide you with practical, actionable insights on how to effectively respond to objections raised by the trademark registry, especially during showcase hearings. So rightly, as introduced, I'm Srinivas Mathipati, representing Eeva Patent Services, and I was joined by our colleagues, Suma Roshni and Raj Misa. He's convening the webinar. Thank you. So we'll walk you through common pitfalls, response strategies, and real examples from the field to help strengthen your future filings. Raj, please confirm my voice is clear, no echo, right?
Yes, sir, it's clear. Can hear you. There's no echo. It's perfect.
Thank you. Yeah, so today's agenda is we'll begin with an overview of what showcase hearings are in the trademark application process, why they are important, and what the registry is looking for. Next, we'll discuss the two main grounds of objection under the Indian Trademarks Act. So those are Section 9, which deals with the lack of distinctiveness, and Section 11, which relates to potential confusion with the existing marks, which will be pending by the stage of trademark showcase hearing. Following that, we'll show you how to structure replies effectively using real-life examples and what kind of evidence strengthens your case. Then the case studies with tips to overcome objections. And finally, we'll wrap up with a few questions from the participants. I'll start with this basic slide, understanding types of trademarks. So trademarks are not just names. They come in many forms, and each plays a unique role in brand recognition. So the prominent example, Coca-Cola trademarked the name as their word mark, and also they trademarked their bottle as shape mark. And we know the well-known McDonald's, the symbol or device mark. So, and also their slogan. So I'm loving it. And this color mark from orange, so a color trademark. And Volkswagen, a best example of the device mark as per Indian Trademark Act. So this is an example of a logo type, a stylized combination of letters with a symbol. It's a device mark protected in its exact form. So why does this matter? So when we conduct a trademark search, we must identify what type of mark we are dealing with. So if it's a word mark, we do a phonetic search and see any phonetic similarities in the results. If it's a logo or shape mark, we need to use Vienna code to identify visual similarity. And if it's a color or slogan, so we need to analyze whether it's distinctive enough. Though we don't have a kind of search strategies available on Indian trademark search portal for directly searching for color or slogans. As well, it is not that easy to even know about Vienna code and then search for logo or shape. So we need to take care, we need to spend some time before actually deciding to file an application, which are more of color, shape, or maybe the slogans. And this is the workflow or maybe the process flow chart of trademark registration in India and in any other country. So it typically starts with the trademark search and identifying of proper classification classes for the mark, filing an application, and there will be a formalities check from the trademark registry in India, and then an examination report. The typical timeline to get an examination report is normally 2 to 3 months, but though it is not given in the act, the turnaround time, but it is typically 2 to 3 months. But as on date, it is taking around 9 to 10 months to receive an examination report for an application newly filed. And this examination report can be an acceptance report. That means like the application has been accepted and will be published very soon in the Trademark Office Journal. That means like from the publication in the Trademark Office Journal, after 4 months, 120 days effectively as per Trademark Act. So the application which is accepted will proceed to registration. But in case like the examination report is not an acceptance, it's not a positive order. In that case, like it will have the objections raised by the examiner. That means like within 30 days from the date of examination report, we need to reply with the satisfactory submissions. If not, like the application proceed to abandonment, though it won't be abandoned immediately after 1 month, but formally as per act, it is deemed to be abandoned. And after examination report reply, after the objection report reply, if the trademark office conducts an re-examination, or they will review the submission made by the applicant or the attorney representing the applicant. If he is satisfied, if he or she is satisfied, then the application may proceed to be accepted and being published in the journal. If not, a show cause hearing will be issued. So a show cause hearing is the final step or the final chance for the applicant to convince the trademark registry. If not, the application will be refused. So we'll see what are all the grounds or the objections at maybe the trademark. The application may receive a negative examination report. As well, it may proceed to show cause hearing. So these are two important sections, Section 9 and Section 11. Section 9 are the absolute grounds. So this section focuses on the inherent qualities of the mark, regardless of whether anyone else has used it or not. So this we will make sure during the search, but even the trademark office, if we miss, the trademark office may find the similarities. And the other aspect is the generic or descriptiveness, and some restrictive words as well. And it can be geographical terms like Hyderabad, Amravati, Godavari, or it can be religious or immoral terms like, for example, religious Mahalakshmi fashions or Sri Lakshmi curries. So these are the examples. These are all the aspects like the trademark office considers during the examination to accept the application. And the second important objection is Section 11, that is relative grounds. The earlier ones are all absolute grounds, and Section 11 deals with relative grounds. Section 11 looks at conflicts with existing marks. It's about market confusion. A trademark may be refused if it is visually, phonetically, or conceptually similar to an already registered mark or pending mark. So there is a likelihood of confusion among consumers. That is the main objective of trademark office referring to this section in their examination reports. Examples are the Lux versus Lux, means LEX versus LUX, or Star Cup versus Starbucks, Star Cups versus Starbucks, or Nike with a different spelling with actual Nike. So this is the objective of the trademark office objecting under this section, the likelihood of confusion. This is where a trademark search plays a major role. It's your early warning system. The trademark search is an early warning system to spot overlaps and avoid disputes. The conclusion is, so when naming your brand, avoid descriptive, generic, or overused terms. Avoid similar sounding names, even if spelled differently. And most importantly, run a search first, because these two sections are the biggest hurdles to registration. We'll see some examples. So there are many popular brands in this slide. So descriptive versus coined marks. Some had acquired secondary meaning and been accepted based on exceptions. like the Charnar cigarette or Taj Mahal tea, the Dabur homemade. So these acquired their secondary meaning, though they are descriptive, they are generic, or they are suggestive, or they are actually referring to a geographical location. Uh, Acquiring, or maybe initially, if as in trademark application, the trademark registry feels like they are taking undue advantage of the geographic location. And at the same time, Zomato or Tata, Dabur, so though they are maybe the family names of the example Tata, Dabur, but they also acquired a secondary meaning. Zomato is an exceptional example of a coined mark, so which is very unique. So it doesn't it is not it is not neither descriptive or suggestive, or it is not existing in the registry in the Google itself. If you search Zomato, and fresh to home Munchie Buffet, again descriptive, suggestive, and maybe after some time, like they should have acquired the secondary meaning, and then they are accepted. So these are the very good examples, like while conducting a search, while thinking of um, having a good brand name. So we have to understand how trademark registration works, and how the branding works, considering these examples. So we'll move to key concepts in Shoka's hearings. Why Shoka's hearing is issued after being replied to the objections in a formal way with the objection report reply. A trademark Shoka's hearing is the stage where the registry gives you a final chance to justify your application. So most common objections in the Shoka's hearings at the time of Shoka's hearing pending are Section 91A and Section 11. So Section 91A is about descriptive or generic marks. So example, trying to register delicious for biscuits. And if it is Section 11, similarity with earlier marks, example, TechMate for laptops objected due to TechMart. I'll show you that example. So this is Section 11, likelihood of confusion. So I took these two brands from Google. So I'm not like giving an opinion whether they are good brands or not bad brands. So it's only for the understanding key concepts in the Shoka's hearing. So Section 11 objections related to the existence of earlier identical or similar trademarks in respect of similar goods or services. So the concern is that registration of the new mark may cause confusion or deception among the public. So Tech Card for electronics, when Tech Mart already exists, could raise an objection under Section 11. So the objection is about visual, phonetic, and conceptual similarity between both the brands. Tech Mart, when it is already existing, so Tech Card cannot be accepted as per trademark registry. So, and how to respond in a similar case. So emphasize on the differences in logo, color, style, as well the goods and channels of trade. So this is very important. So TechMart, as introduced, it is for laptops, and they registered their trademark in class 9, and not in class 35 for trading. But for example, Tech Cart, like the name itself is actually suggesting it's a online marketplace, but Tech Mart is not an online marketplace, and they are actually the manufacturers of laptops or maybe accessories. So Tech Cart, though they sell laptops, they sell accessories, they sell all the goods that fall under class 9, but they are not manufacturers. That means like there is a clear distinction of the goods or the services they are registering for, and the channel of trade. So that is also different. And the logo is different, the color is different, and the style is different. So these are the key differentiators that we can actually emphasize during the objection report reply. Or if it proceeds to show cause hearing, then even in the show cause hearings, like we can provide evidence, like comparing with the trade channels or the goods or the packaging of tech mart with tech cart, also supporting with certain usage proofs of tech cart, their domain registration, their portal screenshots, and their social pages, as well the invoices not claiming the product name. So they are the service providers under class 35. So this is the clear distinction that we can actually make during the show cause hearing while we are actually defending our case. Formally, orally, when we connect with the show cause hearing officer, and then before or after, like by providing a written submission to that effect. So this is one example, and we'll move to another example and related to section 91A, lack of distinctiveness. So here, like we have some examples, and we can take the fresh to home example as well here. So under section 91A of the Trademark Act, the registrar can object to marks that are not inherently distinctive or capable of distinguishing the applicant's goods, services from those of others. Words like fresh, sweet, natural, organic for food items are considered generic or descriptive. A mark like healthy oats, fresh to home for maybe e-commerce of fresh vegetables or fruits delivered. So may be objected under this section. How to respond to this section if the objection is still hanging on at the time of show cause hearing. So we have to demonstrate that the mark has acquired distinctiveness through extensive usage. This is the only way to get out of it. Through advertisements, through consumer recognition. That means like we can conduct a survey or maybe online voting, not voting actually, it's a survey is effective. Asking our consumers as well outside of our consumer bucket. So we can ask whether they know this brand by showing the packaging or maybe certain products under the brand name. And then that proof in the form of an affidavit, if you can submit, like then that the secondary meaning acquisition aspect can be brought out, and then we can with an user affidavit, like we can actually convince the registry. So we did it in couple of cases, though we cannot actually disclose the cases, but one to one, if someone wants to have an understanding, we can share them. Thank you. And next thing, yeah, we have seen this, and I just want to uh, show you an example, recent example. This is a strong example of Section 11, likelihood of confusion, where the court decided in the favor of the existing mark. And then this is between Milma versus Milna. So case decided by the Commercial Court in Kerala. In this case, the defendant Milna adopted a name and packaging design that closely resembled that of the plaintiff Milma. Milma is a milk producers or the Farmers Association in Kerala. So Milma, well-established dairy brand. So the court found that the visual and phonetic similarity between Milma and Milna, particularly in the stylized script and packaging color scheme, was likely to cause confusion among consumers. So court applied the principle under Section 11(1) of Trademarks Act. The court ruled that the impugned mark infringed upon the prior rights of Milma, whose brand had acquired significant goodwill. So that the judgment resulted in a permanent injunction and an award of 1 crore in damages, demonstrating the critical importance of avoiding marks that bear resemblance to well-known or previously registered trademarks, even where the differences may appear minimal or justified. So this is a recent judgment, and I am taking more examples of Section 11. Um, this is again this is a well-known settled judgment. So between two institutions, Goenka. So Goenka is the family name, or yes, obviously the family name of the promoters or the president of the educational societies of both the institutions, group of institutions. So the first use is very important here, but though the first use is there, if the second one is a honest adoption, so the mark was coined or adopted to in good faith, not to raid or
Uh, Sir, could you please unmute? I'm sorry, I pressed that. Yeah, sorry.
yeah. So in this case, both the parties use the term Goenka. So in their trademarks for educational institutions, the court found that both parties had started using the mark around the same time and in different geographical regions. As a result, the court allowed the registration of both marks subject to certain conditions, such as requiring the appellant to include the name of their trust in brackets below the name of their institution to avoid confusion. So initially, the Anjani Kumar Goenka, Sri Anjani Kumar Goenka, the first applicant, they had multiple registrations and they opposed the other one. And the registry also refused many applications made by them. And after that, after the court ruling, so they recently filed an application by including their trust name. So, and then it has been accepted. So, and this is I think I have missed one more screenshot. But anyway, like there is another case of Satilila Charitable Society versus the Skyline Education Institution. Again, the mark Skyline, word mark or the device mark Skyline, in this case, the court allowed an engineering institution to continue using the name Skyline despite the existence of another institution with the same name. So the court reasoned that students are not ordinary customers and are likely to be well informed about the education institutions they choose. As a result, there was no likelihood of confusion among the student community. So the doctrine of honest and concurrent use plays an important role in balancing the rights of trademark owners and promoting fairness in the marketplace. It provides a legal remedy for businesses that have been using similar marks in good faith and allows for the coexistence of trademarks in certain situations. However, the application of this doctrine requires careful consideration of the facts and circumstances of each case, particularly the likelihood of consumer confusion. So while making the applications or while dealing the objections during the Shokas hearing, like we have to consider or we can refer the established cases and then we can take advantage of. But if there is a concurrent and bona fide use or uh, parallel use, but not really inflicting or conflicting the others' rights. And to conclude the objections related to 9 and 11, so this is the example related to spices in class 29, 30, or maybe in class 24 and 35. A brand like Cotton World or for textiles, so cannot be distinctive. Only the stylized writing of it can be claimed if it has acquired the secondary meaning or maybe distinctiveness. The key points here actually are the proper usage proofs and timely filing of the examination report reply, and also timely submission of proofs and affidavit in the form of an affidavit before the hearing, so that like we can put forth our case more effectively. And the comparison, the distinctiveness comparison between the packaging and the style of use, and the proofs related to honest adoption in the case of the institutions, or maybe the parallel usage of two same brands, same names in the market in two different geographies. So that honest adoption with proper proofs need to be submitted to get out of the objections. And practical tips for Shokas hearings to handle the Shokas hearings are the always file an user affidavit and invoices if mark is in use. So never ever during the filing name it as proposed to be used if the mark is in use. So we have many cases, burning cases actually, I can say. So a mark which is in use since 2007, they got an application filed by an agency. I won't name it. So they filed this application as proposed to be used. So they have uses from 2007. So they are a prominent, well-known mark. I don't say well-known mark, but well-known brand in Hyderabad. Though the same name or the same word is being used elsewhere, like in other parts of India, not in Telangana or Andhra Pradesh or in South India, before this brand in Hyderabad. So though the mark is used in other parts, but they have their distinctiveness, their style is different, their logo is different, and their color combination is different, and they have concurrent and fair use in this region. But the agency or the attorney didn't consider anything. So though I checked after from the applicant side, so they have provided the usage proofs as well. So they had a website, they had listings on Zomato and Swiggy, and they provided invoices as well before filing the application. But the mark has been filed as proposed to be used, and it came for a Shokas hearing as well. I don't know. I mean, why trademark registry doesn't. I mean, as it is proposed to be used, like they haven't asked any proofs. So they only asked like there is a similar mark, and we don't know what the attorney had told the hearing officer during the hearing. It was accepted and it is registered. So now the purpose of this application is to actually stop infringers in the marketplace on Zomato and Swiggy, and their registration is of no use as on date. But like it's not completely of no use. But the thing is, like, it is proposed to be used, and they cannot actually go to court and say like I'm using it from 2007 and I have this issue, because they themselves admitted that it is proposed to be used, which is filed in 2022. So now they had to make one more application as a word claiming 2007 usage, though it is tough for them, for the applicant to give usage proofs from 2007, but they have substantial proofs that being because like they are selling online, so it is not that tough to get invoices. So they are selling online from 2012, 13, from their own website initially, and then on the different platforms. So they are in a position after the second application's acceptance with the usage of 2007. Now they are actually are in a position to defend the infringements. So this is the thing. So always file user affidavits and invoices if mark is in use at the date of filing, and provide factual replies addressing exact objections. This is the way. This is very important thing. Comparison, or maybe like side by side comparison as well. Marketing material of the other brand, marketing material of our brand, and avoid generic justifications like just like writing a case law and actually writing that this is different and this can be considered under this. So we have to use case laws, so not excessively. we have to use them judiciously and check alignment with registry's recent decisions. So this is more important. So we can refer to recent decisions from the High Court as IPAB is no more there. So from Chennai High Court or Mumbai High Court related to trademark under section objections under section 911 and their interpretation. So this will be very useful. So this is it. And the most important is, so during the filing, if there is a usage or the applicant wish to use immediately, then it's always better like we submit an user affidavit with existing proofs. And by the stage of, if there is an objection from the trademark registry during the objection reply, like we need to give some more proofs showing our usage. And if it further proceeds to Shokas hearing, then before Shokas hearing, like we need to provide, it is always better to submit a written submission, a written note, along with some more proofs, and then actually put forth our argument before the hearing officer. And there is an always a chance of 99% of acceptance, unless it is under section 11 and there is no uh, proper adoption. So in that case only the marks will be rejected, but otherwise like all the marks will be accepted. So if you have usage and though the same marks are same. So like in the example of Goenka or maybe any other example, we have our own examples as well where we dealt these cases. So we can have further discussion one-to-one. And if there are any questions, I'm happy to take a few here. Raj, any messages in the chat box?
No, one of the participants pinged me. He's from the WhatsApp group. I don't know if he's our own Sasidhar or somebody else, but they just asked about the replay of the recording because they're busy at their work or they can't catch this live.
Okay.
He just pinged me. But apart from that, any of the participants, is anybody in the participant list who joined this webinar for the first time? Just drop in the chat saying FT. If you're here for the first time, or if anybody has got any questions, please feel free to unmute. Okay, let me enable unmute. Yeah, feel free to unmute and you can speak or you can put it in the chat. Okay, we have no first timers.
And we are continuing this next after Shokas hearing after acceptance and related to oppositions before registration in our next session next week, next Wednesday. So what if a third party opposition, and what are the things that we have to take care before actually filing our counter? And then maybe in the next session we will take about the evidence stage of the opposition and the hearing stage of the oppositions.
Okay.
So let us circulate the poster and then yeah. So we'll
Definitely,
target
sir.
more participants also.
Yeah, sure. Thank you, Hari Krishna and Akshata Sangogi, for joining in for the first time. So apart from the IPR series on Wednesdays, if you have any feedback in the official WhatsApp group of Eeva Tech webinar WhatsApp group, there will be a link. Please feel free to drop in any comments or do drop in your feedbacks. And also just Google Eeva Patent Services, you'll find us. Feel free to hit that 5-star button and share your experience openly and genuinely. And also you can stay connected with us at the same Eeva Patent Services handle on all the social media handles. So we have a target of our own to reach 2025 Google reviews. That's a number which is definitely achievable based upon the kind of queries which we get through our website or social media handles or So 6 more months to go, half of the year is over. And if anybody is willing to help other startups launch their brands, be it under solo proprietorship or under startups or MSMEs, feel free to get free advice or the genuine advice from Srinivas Madhipadi Garu. If you just Google the name, you'll find all the links. And we are quite active on LinkedIn, even quite active on the other handles as well. But we are just a message away. Mainly in the IPR space, we do have lots of attention, but we will be very glad to help you out, taking only the nominal government fee, which whatever the basic nominal fee with little or extremely low professional charges by the entire team. So thank you so much, sir. We will see you live again next Wednesday. Anybody else, any questions? Like Akshata or Hare Krishna, do you have any questions as you are here for the first time? Other participants, Priyanka, Roshni, Naga Satish. Yeah, thank you, sir. And I've also got correlation to IPR, again, with respect to consistency or with respect to branding and with respect to publishing content. So Sasidhar asks if the same word mark with different spellings can we get by any chance? So thank you, Hare Krishna Garu, for that wonderful comment. Excellent service from 2020. So, sir, Sasidhar question is like, so can I have instead of Eeva Tech, can I have like Eeva Tech? Like Eeva is also a common name. Like mostly Eeva goes to a brand which is female and all EVA. So if with a different spelling, is that possible, sir? Like even
Yeah,
the
if this is the case, example, TechMart and TechCart. So like TechMart manufactured in class 9 and they also trade on their website. For example, TechMart, they also means like they are also selling online. TechCart is a e-commerce platform which again sells white labeled or maybe different brands of laptops and accessories where TechMart will also do. So if this is the case, so TechMart, the prior registrant having registration in class 9 as well, class 35, and TechCart, they are not applying in class 9, but they are only applying in class 35 as a marketplace. So if this is the case, then yes. So we can differentiate in terms of, again, it should be a genuine use case. So TechMart is a brand, so they are not imitating their brand image or logo or style. And then this is TechCart is purely they are not having manufacturing, so that proof we need to show or we need to emphasize. And they are not manufacturers; those they are only sellers or traders. So this case, yes, it is possible. And this case, yes, the court ruled, no, it cannot, because they are deceiving the public by having a similar kind of a packaging. So they just changed here and there. So Milma in the place of M, so they made it double N. And again, if you see double N combined as M, so this is cheating purely. So
but again the shocking thing is the 1 crore in damages which you mentioned as a penalty. That was shocking for me. I don't know. They might
courts
have
are accepting the as per act. It is only 2 lakhs. The capital damage can be given to the plaintiff, but yes, they are calculating like again like the attorneys on Milma side. They should have shown their loss in sales about the time when this Milna came into picture or started selling the product. So with that proper justification, the court can actually grant an injunction and as an award as well. The capital award, actually, the suit value is 1 crore, and the court accepted to grant it as a damage.
Yeah, and they clearly mentioned Kerala milk below the logo, which is again very smart way of um, projecting the application
And
of.
Shashi's case, like these are the two examples where like one is a proper adoption and of different class, though the relevant class is there in between. And this is the case like it's a pure misuse. So in both the cases, though it is, I mean, the application will be referred to Shuka's hearing, and then based on our submissions, like it will be accepted. So in Milna case, like they don't have a trademark at all. So they showed it as R without a registration. So that is also one misuse or gross misuse
Okay.
of Trademark Act again. And in some other example, maybe this case, for example, if you take fresh to home, and it is, for example, fresh to home with the number two.
Okay.
And fresh to home is a platform, and fresh to home, it should be again relevant. But if the class is different, or the within the class, like if it is only one product or something like that, and if both are in different geographies and the style or the logo is different. So though both are primarily first, they are not eligible for registration as they are descriptive, but still one is accepted based on their secondary meaning acquisition. The same way, the second also need to be accepted based on their secondary meaning acquisition. So even book my show, make my trip, all these things are descriptive, suggestive. So we see like after make my trip, there are many other portals reflecting same like make my trip and book my show. So book my Tyler, book my car, book my something else, book my show, book my stall, book my
Calendar also. Even I've seen one of the startups had come up with Book My
they are
Calendar.
not again copying the style of this black and white, I mean, sorry, red and black combination of Book My Show, not highlighting that my way like that. They did it in Make My Trip or Book My Show. If that
Oh,
is,
okay.
it's like it's a proper adoption and that can be accepted.
Until you highlighted the word "my," I didn't notice it. In Book My Show, it's like the ticket చింపినట్టుగా the "my" is portrayed,
Yeah,
and in Make My Trip again, the "my" is like probably the cloudy
yeah.
curve. But fresh.
Shishtar is asking Vishwak and Vishwak. VIS VAK and VIS WAK. So it is phonetically similar. And if they both are into same class, same product, then no. So the trademark office will refuse the application. If
Yeah,
they are in different jurisdictions and both, I mean, though both are in same class but of different products in the same class, then and they have usage. For example, the second one also has usage. So Viswak already registered VISWAK. For example, for masalas in class, uh, yeah, with a different logo but different product as well and different geography, and also having the Viswak VISVAK, the new one, if they are having usage, maybe more than 3 years by the time of application, then yes. If they don't have any usage and they are filing fresh and starting to use fresh, then there is always a chance that they can show they are different, because they know, the attorney knows like how to show difference. That means like they'll definitely package different, but they do the same class trading and the same area. So for that reason, they won't be allowed. Unknowingly, if they adopted, like Viswak is already there, Viswak they started last 3 years back or 2 years back, then yes.
And with respect to this brand, sir, now I really had this doubt because when the celebrities, when they launch their own clothing brands and all, this brand, though that's like a negative word. So how does that work, sir? Because we know that rowdy is such a negative word. Even when I was thinking about the word damn, but I was like correlating it to damn good or damn sure.
No, your own application is there, right? We got an objection under Section 9 because it is offensive. Damn, damn
Yeah.
rules.
Oh, we got objections, sir.
Yeah, yeah.
Okay, I didn't know that. Maybe Satish, I have to check.
So damn and entrepreneurs. So dampreneurs. So damn is offensive. So it has been objected under Section 9.
So again, like, did we reply back to them saying, okay, there is damn good, damn sure. We want to show that it's strong.
Yes.
Okay. With respect to the Rowdy brand also, I mean, they launched also, they launched the showrooms, they launched the products with the word Rowdy.
Yeah.
It's always in my mind. So how do they get approval for this, sir? I mean, do they show that it's also in use since
They
2018?
have to show that they had a secondary meaning adopted. The people rather the offensiveness of the name. So they accepted it as a brand. So they have to show the extensive marketing proof as well, wide acceptance of people in different age groups. They have to show their client list. As an example, client list, they have to make a 70-year-old client buying the brand, 18-year-old buying the brand, a woman aged 40 years old buying the brand.
Yeah, they've highlighted it as
Yeah,
streetwear apparel, sweatshirts, jackets, hoodies.
yeah,
Maybe they removed the O, but when that's what I see here when I Google, but
yes,
it's always complicated.
yes.
So in my case, again, now we have like another 5 minutes, but in my case, do I need to still wait, sir, or is it? I mean, do I need to change my brand or?
No, no, trademark registration ultimately is not a license to do business. So it follows certain conditions which are good for the order of the people or order of the land. So like this one, offensiveness or whatever, geographical indications cannot be trademarked, or generic words cannot be trademarked, religious terms cannot be trademarked. So all these things are good things that businesses has to take care. So trademark office or trademark registry, trademark act actually its objective is to doing business in a good way. So and trademark registration is not a license. Even your uh, brand is refused under class 41 and maybe technology services class 42, citing class 9, I mean section 9 objection, it is offensive. So there is no need like you have to stop using your brand. So you can promote it, and after some time, after 3 years or 4 years, if it is ever refused, so after 3 to 4 years, after acquisition of brand value, then we can apply against showing the consistent use, and then the acquisition of brand image.
So under class 35 and class 41, we can still continue using, I
Yes,
mean,
yes. We'll
okay.
be having only common law protection, not the Trademark Act protection, if it is not registered. But otherwise, you can definitely use the brand.
Okay, sir. Thank you. Thank you so much. Anyway, I'm sure that the video therapy
If it is
network is
ever
not,
refused, so it won't be refused. So mostly,
yeah, I mean, like Eeva Patent Services, nobody can copy video therapy network because it's something which was close to my own journey, my own experience. So I was least bothered about somebody copying video therapy network,
yeah.
though I have the registered MSME and all that. But thank you, sir.
And I hope like Shashidhar got his answer. So Vishwak and Vishwak, it's a good question actually. Thank you.
Under different services, right? Okay.
Yeah. Yeah, he's
So,
asking like for the same service. One Vishwaka is already registered, and someone wants to with instead of W with the V.
yeah,
It's tough. So if it is the adoption is unknowingly in different places, even for the same product with the different packaging and logo, then it is yes. But if it is intentionally doing, like the trademark office obviously identifies it.
yes. Thank you, sir. Thank you so much.
Thank you.
So, thank you all the
Thank
participants.
you all for the
See you.
joining. So see you next week.
Yeah. Thank you, sir. Bye-bye. Bye, everybody. Good day.